Hello, my name's David Sheeran and I'm a Business Advisory Officer with Workcover New South Wales. Today I'd like to talk to you about the new work health safety legislation that has been introduced in New South Wales. We'll be looking at health and safety duties and the duties of each duty holder at each workplace. We'll also look at the consultation arrangements for respective workplaces and we'll look at risk management. New work health safety legislation was introduced in New South Wales on the 1st of January 2012. This was coordinated by Safe Work Australia in consultation with each jurisdiction, being each state and territory, and each duty holder is now required to comply with that legislation. There are, however, transitional arrangements in place, so the duty holders will be given an opportunity to implement the new changes to the legislation. I might point out though that this is about work health safety legislation and not workers' compensation. Workers' compensation legislation can be covered off on another program. The change to the Occupational Health and Safety Act is the introduction of the Work Health Safety Act. The key principles of safety remain the same. So what does this mean for a duty holder? It means that the duty holder still has a responsibility to manage the risk associated with the workers at that workplace and of course establish appropriate consultation arrangements so that each worker has an opportunity to contribute to the management of health and safety at that place of work. We'll now look at the principal duties. In essence, if I am a duty holder under this legislation, my duties are non-transferable. I will always have that duty whilst I'm at that place of work. I cannot delegate that duty to another duty holder. A person can have more than one duty, and also the management of risks is now by elimination and/or control, whereas historically we had looked at risk assessments as part of the risk management process. None of the management of risk would be possible without the effective consultative arrangements with those workers at that place of work. So who has a duty under the work health safety legislation? The first term you'll hear mentioned is a person conducting a business or undertaking, a PCBU. We'll also look at the duties of officers. There will be certain people within a corporation or a proprietary limited business that would be deemed to be officers for the purposes of work health safety legislation, and we will discuss their duties shortly. We'll also look at the term workers. Historically we had an employer and employee relationship. We now look at a PCBU and worker relationship. So this is a broader coverage as opposed to the employer-employee relationship. And we'll also look at others in the workplace, people such as your customers and visitors. They now have a work health safety duty under this new legislation. So basically anybody that comes into the workplace will have a work health safety duty and they'll be required to comply with that duty. Let's look at the definition of the term PCBU and let's look at the broader arrangements insofar as who might be a PCBU. We focus traditionally on employers. We now look at that in a much broader context insofar as we now have included as a PCBU a labour hire organisation, a corporation, a self-employed person, a partnership, sole traders and associations. When we look at the PCBU duties, the introduction of the term reasonably practicable is quite important for the person conducting the business or undertaking. Reasonably practicable replaces what we used to know as the insurance for work health safety under the old Occupational Health and Safety Act. So where an employer would have to ensure the work health safety of employees and others at a workplace, the PCBU must now ensure, so far as is reasonably practicable, the health and safety of workers and others at a place of work. Any workers the PCBU engages or has cause to engage, any workers the PCBU directs or influences at that place of work, and any other, such as a customer or visitor that comes into that workplace, the PCBU will have the responsibility to ensure, so far as is reasonably practicable, the health and safety of those people at that place of work. The duties of a PCBU are such that they must have a safe system of work in place. To minimise the likelihood of a worker committing an error, a PCBU would introduce, for example, a safe operating procedure or perhaps a safe work method statement. Another duty the PCBU would have is of course the provision of a safe working environment. So if my workers were working outdoors, there would be things like ultraviolet radiation that we would need to cover off, so that might be the provision of personal protective equipment as an example. The PCBU must also provide safe plant, safe structures and safe substances. When we look at safe plant and the provision of this by the PCBU, we would ask that the PCBU and the provision of safe plant, as a minimum, would comply with an Australian standard. If this is the case, then the PCBU would be well on their way to ensuring compliance with the Work Health Safety Act. We need to ensure that the plant is maintained appropriately or adequately in accordance with the manufacturer's guidelines. If this is the case, then the PCBU again is demonstrating compliance with the work health safety legislation. The place of work is very important insofar as the structure is safe. You may have a structure that has asbestos. The PCBU would be required to have what we refer to as an asbestos register to ensure that the workplace or the structure itself was safe in accordance with the register. We also have safe substances. We used to use the term hazardous substances. Under the new legislation, we use the term hazardous chemicals. A PCBU must ensure that the substances that are provided to those workers are safe. One of the ways to do this, of course, is to provide the relevant information, such as a safety data sheet, formerly known as a material safety data sheet. The safety data sheet will have all the information that is necessary for the worker to use the chemical. The PCBU must also provide instruction and training to the worker to ensure they work safely. Another element for the PCBU with regard to compliance is adequate supervision. What does adequate supervision mean? Well, I like to look at the term CASH: knowledge, attitude and skill. The other element, of course, is habit. If I perform a task over and over again, that task becomes habitual. This demonstrates or equates to what we would call competence. So if the person is competent to perform the task, we're halfway there in identifying the level of supervision that would be provided. So that's how a PCBU can demonstrate its commitment under the work health safety legislation. Another requirement for the PCBU is, of course, to notify and record injuries and incidents. There are new requirements now in Workcover. If I have a fatality at the workplace, yes, you must report that to Workcover. With regard to serious injury or illness, historically we would have reported to Workcover where a person was away from the workplace for 7 days or greater. The new legislation says if the person is admitted as an inpatient to a hospital, then it is a reportable incident to Workcover. If a person receives an amputation, a loss of limb, loses consciousness at a workplace, suffers a severe laceration, head injury or eye injury, or even burn, these incidents are reportable to Workcover. When we look at a dangerous incident, one thing we must consider in accordance with the legislation is, does it present or pose a serious risk? So, if we have an incident at the workplace, such as an escape of gas or substance, does that present a serious risk? If not, then it is not a reportable incident to Workcover. When reporting to Workcover, we must report by the fastest possible means. Now, this would generally be by telephone. As a result, the Workcover officer may ask you further questions and ask you to complete and provide further information later on down the track. This is quite okay, and it's important to gather as much information at the incident site or where the accident occurred. Another thing to consider under the new legislation is that you must preserve the incident site. Therefore, if it's a reportable incident, I must preserve the site until I'm directed by a Workcover inspector, or if I am retrieving a fatally injured person or rescuing an injured person and or directed otherwise. We must keep records for a period of 5 years. Let's look at the term officers. An officer is someone who makes or participates in making decisions that affect the whole or a substantial part of the business or undertaking, and or makes decisions that affect the financial arrangements of the business or undertaking. If I'm an officer for the purposes of the work health safety legislation, I would need to be able to identify whether I was or not. So if I do participate in making decisions, does that necessarily make me an officer? In essence, it may not. A chief executive officer, a director, a company secretary would be deemed to be officers for the purposes of work health safety legislation. So let's look at the duties of an officer. Now, why we have an officer appointed is because the company itself is the entity. If I'm a sole trader, then I am the PCBU. However, if I have a company, then the entity itself can't undertake its primary duties. It needs someone within that entity or within that company to make those decisions. So that's how we would be able to also identify whether we were an officer or not for the purposes of the legislation. There are 6 due diligence requirements that an officer must comply with insofar as meeting with their requirements under the work health safety legislation. The officer duty is a positive duty, therefore they must be proactive in ensuring they have an understanding of the operation and the risks and the hazards associated with that business or undertaking. This could be achieved by talking to the workers at that workplace, undertaking things like workplace inspections or audits at the workplace to identify the nature of the operations and the hazards and risks associated with those operations at that place of work. The officer must have an understanding and knowledge of health and safety matters. This can be achieved by having in place appropriate consultative arrangements whereby we discuss the hazards and risks and the issues that are associated with that workplace. The due diligence requirements for the officer within the PCBU must ensure adequate resources and processes are put in place. Do I have enough people to do the job safely? Do they have a system of work that they can follow? Is my plant, equipment and machinery maintained, and do I keep documentation of this? Another issue to consider for due diligence is a timely response to incidents and issues. The officer within that business must ensure the PCBU has in place appropriate arrangements in which to respond to an incident. An example of this is there an emergency evacuation plan, procedure and muster point in place at that place of work? If this is the case, then this is one example of demonstrating commitment from the officer's point of view. The other thing to consider and final due diligence requirement is, of course, the legal compliance. So is there corporate governance within the organisation? How do I know that my systems actually work? I won't be aware of this unless, of course, I undertake an audit. So the structured audit could be done internally or it could be done by an external organisation. The choice rests with the officer and the PCBU. So legal compliance and verification is very important because overall it looks at the whole systematic approach to work health safety within that business or undertaking. Let's look at the duties of a worker. Historically we would refer to as a worker as an employee, and the historical relationship was with the employer and the employee. This has broadened the scope, providing a PCBU and a worker relationship which encompasses many more people at that place of work, whom we traditionally may not have thought would have been one of our workers. So, as we know it, we may, at some time, engage a volunteer. A volunteer, for the purposes of the work health safety legislation, would be a worker of the PCBU. Other examples to consider are work experience students, labour hire staff, subcontractors, contractors and apprentices. So you can see that the scope is quite broad with regard to who may be a worker at my workplace. If I am the PCBU, I will have to ensure, as far as is reasonably practicable, the health and safety of those workers and others at that place of work. So let's look at the duties of a worker. A worker must take reasonable care for the health and safety of themselves and others, to follow the safe systems that are put in place by the PCBU, to use the plant and equipment safely, and to ensure that their actions don't cause an injury or an incident at that workplace. So, what I do, I am responsible for as a worker because the legislation provides me with that duty. Further to this, I must comply with any reasonable instruction from the PCBU, and I must follow the policies and procedures that relate to that business or undertaking. If the organisation has a safe system of work, as a worker, my duty would be to cooperate with that safe system. Work health safety legislation also imposes duties on others. Others in the workplace may be a visitor, a client, a family member, or even a customer. The other has a duty to take reasonable care for their health and safety, and that their acts and omissions do not cause a health and safety concern for others at that place of work, being workers or even other customers. Others must comply or follow any reasonable instructions from the PCBU. So if there was an area where the PCBU had isolated and had fenced that area off with adequate signposting, it would not be unreasonable that the other would